Hey, what's up, guys? I hope everyone's having a good day. I wanted to shoot a very, very important video today because, as you may or may not know, we are releasing a SMS or text message platform on July 21st, so this coming Thursday, depending on when you're seeing this video. But I've had a lot of people asking questions about it, people that have done mobile marketing in the past, and a lot of legal questions being asked. Now, I am not a lawyer, so let me give you a word of caution here. I am not a lawyer, but we did hire our lawyer to make sure that we had crystal clear guidelines of what you can and cannot do from a legal perspective when sending out SMS messages. Okay, the laws are very clear, and if you do not follow those laws, you can have significant consequences, as I'm going to be showing you here in just a few minutes. Okay. Now, one of the things that you don't have to worry about with our platform, it's called Text Deliver. We have built in these legal requirements for you. So there's really no way that you can not follow the law with this platform. But if you are using another platform, you may want to double check and make sure that they cover all of these bases, because unfortunately, not only the platform, but you could be responsible for any type of legal action that could be taken by another company or an individual. And like I said, the financial issues that you could be facing could be dire. So you have to be careful. Just kind of a word of caution, okay? So I wanted to talk about this. I have a presentation in front of me. This is from Tatango. This is a very well-respected SMS platform out there. They've done a really, really good job of kind of outlining exactly what the requirements are. Okay, and so I thought I would just share kind of the Reader's Digest version of their presentation. Okay, they did a whole webinar on it, which was awesome. But this really summarizes it. So, understanding what's called the TCPA requirements, and I'll go into what all of this is. So there's three different associations that kind of regulate or provide for mobile marketing. Okay, the first one is the CTIA. Okay, this is the Wireless Association. This was created by all of the wireless carriers. Okay, and they're in charge of enforcing SMS just marketing practices. Okay, now it's kind of muddied in terms of what they can and cannot do. The guidelines that they provide are not technically law, so you can't be sued by violating a CTIA rule. Okay, but these are the FCC, which is regulated by law and can sue you. Okay, they look at these things, right? So things like having very specific in regards to text message marketing. So having the words message and data rates, right, may apply, or help and stop commands. So sending stop to opt out, right, giving a way for people to opt out. The message frequency, links to your terms and condition and privacy policies. Okay, these are all best practices that were outlined by the CTIA. Again, they're not. They can't sue you technically, because this is this is just an association that was built by the wireless carriers. But okay, the next one, the FCC, the Federal Communications Commission, can sue you. Okay, so TCPA is the Telephone Consumer Protection Act. Okay, this is a federal law. So it's all about businesses receiving permission from the consumer to text message them, and the specifics around how this permission can be gathered and what is allowed after the permission from the consumer is received. Okay, so we're going to dive into more specifics on this in just a second. Okay, the third is the MMA. This is the Mobile Marketing Association. They've also released their own best practices, very similar to the CTIA. It's a little bit different. Again, this is not a legal entity. You can't be sued by this, but it does kind of create industry confusion. But they also provide some best practices. Now, the very first and foremost thing that you need to understand when you are messaging anybody through commercial text messaging, okay, you need to have prior written consent. That's number one. And not only do you need to have prior written consent, you need to be able to show, you need to be able to verify that you have consent. Okay, 2 requirements to get prior written consent from your customers: either prior written consent, a disclosure, okay, or disclosure must be clear and conspicuous to the customers. So, meaning that you cannot opt them in without them rightfully knowing and making it clear and conspicuous that they are being opted into a text message list of which that you are allowing to market to them through text messaging. Okay, so this is kind of the very basics. When they opt in, they need to clearly know that they are opting in. Okay, now here's a few CTIA requirements. Okay, the first one is for a reoccurring program description and subscribe to receive reoccurring SMS offers. So when someone opts in, they need to have a stop instruction. So text stop to opt out. There needs to be some sort of a way for them to know, hey, if I want to opt out of this list, this is how you do it. Okay, a cost disclosure and telling them that messages and data rates may apply. And then having some sort of a link to your terms and conditions, privacy policy, how and what you're able to do with that contact, right? Now, here's a really good example of a text message, right? So you opt in, say 20% off your next purchase. Text Bob's to 12345. Okay, and subscribe to receive reoccurring SMS offers. Okay, so first they're telling you what you're going to get. Okay, then they're saying you can receive, you're subscribing to receive reoccurring SMS offers. Okay, so it's very clear about what they're getting. Okay, now it also says by participating, you consent to receive text messages sent by an automated telephone dialing system. Okay, consent to these terms is not a condition of purchase. Okay, message and data rates may apply. Text stop to opt out. Terms and condition, privacy policy, go to this link. Okay, they're providing everything that is required based on the TCPA and CTIA requirements. Okay, so it's pretty simple stuff. It should be pretty obvious, but if you do not have these things, then you could have a potential problem, and I'll explain again more in a little bit. Okay, so more messaging requirements. Again, like I was saying, you need to have some sort of opt-out mechanism, whether it's them texting you or them contacting you and you having a way within your system to manually unsubscribe them. Okay. The other thing to know is you cannot send before 8 a.m. and after 9 p.m. from the subscriber's time zone. So the platform that you're using must be able to capture the local person's time zone. So, and then when you go to send a message, you need to make sure that you're not sending before 8 a.m. or after 9 p.m. Okay, similar to cold callers who are calling people, they have to follow similar guidelines. Okay, so if your system doesn't regulate this, then that's a problem for both you and the platform, right? So you have to be careful, and that's one of the things that we've built in to our platform. Okay. Now, mobile opt-out or mobile opt-ins. You must keep copies of all advertising that promotes your SMS campaign. Okay, so you have to keep records of this. Keep a record of all mobile terminated and mobile originated messages. So you must collect their IP address. You must say, you must show a record of when they opted in and then when they opted out. Okay, you need to be able to show this if for whatever reason you got audited, right? And then web opt-ins are a little bit different. Screenshots of the consent web page as seen by the customer. So as long as you have the web URL of where they're opting in, then you should be fine. Okay. Complete data records submitted by the customer. So you must have, we collect IP address, we collect name, email, phone if they provide it, but having a clear record of that person, right? And then you must also, let me go to next page here. So for record keeping, okay, it's your business's responsibility to bear the burden of proof for both, okay, to demonstrate that a clear and conspicuous disclosure was provided, like we talked about, and the customer ambiguously consented to receive text messages to the number he or she specifically provided, okay. Now, if you're going to be importing text message numbers, which we do not recommend, you need to have some sort of a way to prove that they opted in and that they are that you demonstrated clear and conspicuous disclosures and that they consented to receive text messages. Now, the other thing that you need to do is to protect your business is it's advised to maintain each customer's consent by at least 4 years, okay, which is the federal statute of limitations to bring an action under the TCPA, which means that after 4 years, based on the statute of limitations, you can't be sued for something that happened more than 4 years ago. So it's important to keep records of all this just in case for at least 4 years, okay? Now, customer lawsuits. Here's where it gets kind of scary, but it's important to know this stuff. A customer lawsuit. A recipient can claim damages of up to $500 for each text message. Okay, each text message. And willfully or knowingly violating, if you violate the TCPA, court may increase damages to $1,500 per text message. Okay, and I'm going to show you how this can quickly add up in just a little bit. Okay. There can be state initiative civil actions against your company. Complaints may be filed with the FCC, which has the power to assess penalties against your company. Okay, so this can be serious stuff. That's why I wanted to kind of get this out here. Okay, I don't mean to scare you, but it's important to know this stuff, right? Now, there have been plenty of notable lawsuits. Now, this is on a larger scale. Obviously, some of these companies are some of the biggest companies in the world. They have probably a much larger list, but still, this can happen on a smaller scale, right? So Steve Madden, everyone knows Steve Madden shoes, right? The consumers claim that Steve Madden sent them text messages about Steve Madden products and events without their consent. Settlement, $10 million, okay? Papa John's did something similar. The lawsuit was $250 million, okay? Jiffy Lube sent over 2.3 million customers text messages without their consent, $47 million, okay? 20th Century Fox, $16 million settlement. Okay, Simon and Suture, $10 million company. Settlement's still going on, okay, but they're in the process, right? So obviously, guys, this is a pretty serious thing to consider whenever you're doing any type of SMS marketing, and same thing with email marketing or whenever you're going to be contacting people. And so just be smart about it, right? Be smart about how you are collecting your customers' information, how you're storing that information, how you're messaging them. And it's important to be cognizant of all of these rules and regulations. Okay, so like I said, I mean, a lot of people have been asking me a lot of these questions because we are getting close to releasing our application, and people have just been, curious. What can I do? What can I do? Again, I'm not a lawyer. We did hire a lawyer, and these are all things that we are very cognizant of and are making sure that we are including inside of our app. So take it for what it's worth, but I hope this is just kind of like a little heads up. And just be careful out there, okay? Hope everyone has a good day. Hope this was helpful, and I'll see you guys soon.